As I said, it has to only apply in situations where the legislature cannot have foreseen in advance the unique circumstances of a particular fact pattern. Otherwise, we presume that the legislature, in its infinite wisdom, could foresee routine issues of personnel files and investigations. And so they've already balanced all of this, competing privacy and other interests in these exemptions. Personnel file is one that is frequently encountered, and those of us who aren't familiar with the Open Records Act and who aren't familiar with the case law probably think of a personnel file as you might think of your own personnel file with your employer. Just anything having to do with what you do on the job, put in a file, and not just salary information and advancements and promotions and demotions and all of that, job performance evaluations. That's not what personnel files is. Remember, personnel files is excluded. It's a mandatory non-disclosure. A records custodian shall not disclose personnel file information. And it's a convoluted definition of personnel file. But what the definition says is it's things maintained because of the employer-employee relationship, things like home address, home phone number, and personal financial information. And in this 1999 case, the Colorado Court of Appeals said that because it's a mandatory non-disclosure provision under our statute, it's to be construed narrowly, as all exemptions from disclosure are. And what it means is that it's only information like the examples the legislature gave, like home address, home phone number, personal financial information, meaning information unrelated to a public employee's official conduct. That's the only information that is personnel file. Unlike the Federal Freedom of Information Act that has a balancing process, ours doesn't have any balancing. It's mandatory non-disclosure, and so the balancing has already been made by narrowly limiting personnel file only to personal information not related to one's official conduct. And so that as a result of this, that numerous courts throughout the state have rejected the application of personnel file exemption to internal investigation files. They do some primarily in police investigations, but it's also been applied with respect to a judge up in Boulder. An investigation of a public employee's on-duty conduct is not personnel file. By definition, by our statute, and our courts having defined it. So we have successfully obtained, on behalf of the ACLU and numerous press clients, access to internal affairs investigation files of employees throughout the state. So I point that out because personnel file doesn't mean in the law what it means to all of us. I'm going to skip trade secrets. Deliberative process is a huge gap. The deliberative process comes from the Federal Freedom of Information Act and from other, it's just a generally recognized privilege that extends to pre-decisional memoranda and communications, both intra and interdepartmental. And if you think about it, would swallow the Open Records Act if it were construed as broadly as, in fact, the Colorado Supreme Court did in the case arising down in Colorado Springs, the White decision. In the very next legislative term, the General Assembly reversed that decision and made a statutory exemption. That case said that if material is deliberative in nature and pre-decisional, it's a mandatory non-disclosure provision. And it's still listed in the mandatory non-disclosure, but it's been narrowly cabined to information that is really recommendations and suggestions and so candid or personal that public disclosure is likely to stifle honest communications within government. And even if that is true, and that it hasn't been waived, so if it's been shared outside of the deliberative community that is deliberating about a decision, then it's no longer subject to this privilege. And even if all of this applies, the court still has to balance the public's interest in gaining access to the information against this interest of maintaining open, candid communications. And so it's no longer an absolute exemption. requires a balance, particularly when documents and materials are cited or the basis of governmental action, then there's all the stronger interest in the public knowing the basis for that action. I said I wouldn't talk about the Criminal Justice Records Act, and I lied. I'll just tell you the Criminal Justice Records Act. So records of sheriffs and police departments fall into two categories: records of official action, which are mandatory disclosure. There's no exemption from a record of official action, other than if the statute specifically says. So sexual assault victims are statutorily, their names must be redacted, or not victims, but alleged sexual assault victims, even before they're adjudicated. But starting with an arrest, everything that happens in the criminal justice process, to sentencing, conviction, everything that the courts do, must be disclosed, including an indictment. Everything else is just a criminal justice record. It can be withheld, as I said, if the custodian believes the disclosure would be contrary to the public interest. And so if you divide the two, you'll see that official actions, including mugshots, that is our position and the position of the guide issued by the Colorado court system, are official actions that must be disclosed. Everything else is contrary to the public interest standard. And the truly bad news is that if you go to court on a non-official action record, it is reviewed for under this standard of abuse of discretion. It's an extremely deferential standard. So there's a lot more authority. The reason I did throw this in here is to tell you that sheriffs and police departments and criminal justice agencies have much broader discretion and are given much greater leeway by the courts in making these disclosure and non-disclosure decisions than all the others we talked about earlier. So that's about as much as I'm going to say, and turn it over to Jim and then have some Q&A.
Yes, okay. I work for the Associated Press, which means we write tightly, so I speak tightly. I'm not going to take a lot of time. The main point I want to get across here, both to the folks who are reporters and editors and members of the public, is the reason this matters is this is your government. It really is your government, and these are your records. And how do I know that? Because James Madison told me. Okay? That little pint-sized Virginian is my favorite founding father. Right? And in fact, when I get really frustrated with government entities or bureaucrats who won't give us things that are public records, I have been known to say, when did you first realize you were smarter than James Madison? Tell me about that moment. And I shouldn't do that, right? I shouldn't do it. Because it violates my other rule, and Steve alluded to this, which is when you're in the business of trying to get records, personal reasons or professional reasons, you get more lies with sugar than you do. Always. So smart beat reporters form relationships with the people on their beat. If you're covering the cops, you know who the dispatchers are. You know who the captains are. You know the name of the chief's kids. And you're nice to them, and you ask for things, and you get them, because relationships matter. And that works a lot, but it doesn't always work. And that's why we have these laws. But it is your government, and these laws help us make that airy-fairy, we the people stuff real. You know, the best writer who ever lived at 1600 Pennsylvania Avenue, I think, was Abraham Lincoln. And the best thing he ever wrote was the Gettysburg Address. And toward the end, he has this wonderful phrase, government of the people, by the people, and for the people. That has to mean something. It has to mean something. And these laws let us make it mean something. So, enough with the high-minded stuff. Here's how it works in the real world. I'll give you a couple of examples. The Aurora Theater shooting. We asked CU for all the email records pertaining to James Holmes from their archive. And they charged us $4,000 for that. Now I'm here to tell you, finding all those records off of an email server didn't cost $4,000. It didn't. They probably technically could have gotten it done in half a day. But they charged a group of media organizations $4,000 because they had to go through and redact everything, and boy, were they liberal with the black ink. I mean, they redacted a lot. And the reason we were able to afford that $4,000 is because it was 10 media organizations and we split the cost. $4,000 even for the Associated Press, which is the world's largest news gathering organization, which spends $650 million a year to cover the planet, that's still a lot of money for us. I don't know if you guys have heard about this, but times are tough in the media business. I mean, I'm not selling plasma yet to make payroll, but my colleague Jim over here is. So that's what happens. They charge fees that anyone who understands how fetching email from a central server, anyone who understands that, realizes it didn't cost that much. I was talking to Linda Shapley, who's the managing editor of the Denver Post yesterday, and I was asking her for anecdotes. And she said, after the forest fires this past summer down here out in Fort Collins, they asked CSU for some information about firefighting techniques and costs and things like that, just basic journalism stuff. And CSU came back and said, okay, it's going to cost a little bit of money, probably like $200 to $400. Post didn't hear anything. A week later they asked, and CSU comes back and says, yeah, did we say that? We meant $4,000, just us. Now that is censorship by another means. That's not the classic Pentagon Papers banning publication type censorship. That's merely censorship through the pocketbook. And it's hard enough for media organizations to be able to pay these fees. You can't imagine if you're doing back and you need something because you're worried about crime in your neighborhood or because you're curious about a zoning thing. How are you going to afford that? So I understand that it costs money for government to do these things. I happen to hold the opinion that for most of this stuff, you've already paid for it through your tax money. It's a basic governmental function. Now granted, I'm a bit of a dreamer on this, and I know that's not how the world really works, and fees are going to be assessed, but it is frustrating to me that frequently folks who want to not release the public's information use exorbitant charges to do that. Before we came down here this morning, I picked up another colleague, Jim Trotter, who's an editor of iNews, and I was talking to one of his colleagues, Kevin Vaughn, who reminded me of, and this is so pathetic, it's hilarious. After Columbine, Kevin was working at the Rocky with Jeff Cass, and they asked the Jefferson County Sheriff's Office for, was it emails? Lots of emails having to do with Columbine.
All emails with all agencies investigated.
Jefferson County Sheriff's Office came back and said, yeah, we can do that for you. It's going to cost $1.07 million. But you can drop off a cashier's check for half that amount, and we're going to go. Really? $1 million. $1 million. That, you know, that's us not being able to do our watchdog job. That's why we exist. That's why James Madison gave us that wonderful amendment. God bless him. And that's bad. And that's how it works in the real world. Two more quick anecdotes. The AP is involved with some Wyoming newspapers right now in a case with the University of Wyoming where they're hiring a new president, and we asked to see the list of finalists. And the university said, no, if we give you the list, then people will be afraid to apply for this job, which is, of course, hockey because lots of states, this is public. So we won a couple of weeks ago. The district court judge said, yeah, you got to give them the list. Immediately, the legislature passed a law changing it, changing the language of the law to close that, what they consider a loophole. That's what we're up against. There's a word for that, and it's called spite. It was spiteful of them to do that. You know, we won fair and square. Last story. Frequently what you'll hear, both on the federal level and on the state level, is the security exception. I can't tell you this because it's a big security, top secret, secret squirrel deal, and people will die. So I have a friend who I had dinner with a couple of weeks ago in D.C. And he's an interesting guy. He got into a little bit of trouble with the federal government because he told everybody about the waterboarding at Guantanamo. You may have heard of that. And I was walking along with him. Okay, I'll just say we're doing a bar. We're walking along and chatting. And I said, well, you know, I'm a bit of an absolutist on this, but I understand how an organization like the one you used to work for needs to keep secrets. And he said, yeah, except if you don't know about these things, you can't have a conversation about them. And now that we know about waterboarding, we can talk about it. If you don't know, you can't air it out, you can't make decisions. And that's the core of what we're talking about here with Cora. You have to know what your government's doing so that you can make rational decisions about whether you agree, so that you can be an informed voter. I call that democracy. So, there. Q&A.
We'll start here as we go back.
Which exemption under Cora allows sheriffs to keep lists of concealed carry permit holders secret?
Well, again, if you go back to the slide, concealed carry permits are not records of official action. It's not an arrest or an indictment or a charging or sentence or disposition. So it goes under the second category of just criminal justice record. So there isn't any under the Criminal Justice Records Act. This was the bigger problem Jim was talking about, CU's records and emails in Aurora, but there's still a lot of records aside from the gag order that the judge lifted on criminal law enforcement agencies. All records before arrest, or other than those official records, records of official action, are subject to withholding if, in the opinion of the custodian, disclosure would be contrary to public interest. That's all the Criminal Justice Records Act says. They have to articulate some reason why it would be contrary to public interest. Case law is clear that unless they offer any explanation for why they're withholding it, that's arbitrary and capricious and can be at least sent back for yet another chance to articulate a reason, ad infinitum as far as I can tell. So there isn't a specific statutory, to answer your question, there isn't a specific statutory exemption that applies to concealed weapon carry permits. It's just the general contrary to public interest. So a sheriff or police sheriffs issue these have discretion to withhold them, and they have discretion to disclose them as well. There isn't a mandatory exemption that prohibits them from disclosing them to you. Does that answer your question? Well, let's go across that aisle. And be sure to ask Jim questions.
If a government custodian is charging excessive amounts for the records, what recourse is there?
Well, this is the burning question.
There's I give the phone and I say, it's a famous quote from a case law a number of years ago about access to proceedings, judicial proceedings and records, which is another, it's not subject to Cora, but a separate constitutional right of access to the judicial record. And the quote is that access delayed is access denied, that if you don't have contemporaneous access to the proceedings in Aurora regarding James Holmes, but we can get a transcript months later, then we're not effectively monitoring that proceeding. And I think here, under both Cora and the Criminal Justice Records Act, and particularly Cora, I think it's access defrayed is access denied, where, as mentioned, we've seen throughout the state, public entities are imposing costs in thousands of dollars, not just upon the APs and news media of the world, who, as you all know, are struggling financially, but upon common citizens, and thereby making access essentially off limits. It doesn't have to be $1.07 million for the emails associated with Columbine's investigation. $1,000 bill to most people means I can't afford to look at these records. Now, like Jim, the organizations, my clients, and my personal belief is that government, part of the salary of government officials, part of why we as taxpayers
fund our government is to perform certain functions for we the people, including providing access to our records. Remember, they're the public's records, and they are the custodians of them. That's not what the courts have said. And, you know, it's a this isn't a constitutional right of access for a certain we're not, I mean, I wave the flag and say, and wave Madison, and that's certainly the operating principle and the animating principle of the Open Records Act, that we, the people, need to be able to monitor and assess the conduct of our government servants. They are our public servants, and it's the antithesis of a trust us society. The only way we can do so is to look at the records that, and many of you in this room have helped expose significant misfeasance, malfeasance, corruption, what have you. And that's not necessarily the case, that's not the only reason, because even if it's not exposed and we find out that everything was done just right and our government is functioning precisely the way we want it to, that's a public function too. It doesn't have to be exposing corruption, because disproving corruption is also extremely valuable. It's that checking function. And while I agree that it ought to be a right of we the people to have free and unfettered access to records that reflect governmental conduct, that's not what the statute says. And it's not what the courts have interpreted the statute to say. So, you know, with respect to criminal justice agencies, why could Sheriff Stone say $1.07 million? Because that statute says that fees include personnel and equipment devoted to search and retrieval and compilation and now redaction of criminal justice records. So in the Criminal Justice Records Act, there's a straight pass-through. It's statutorily authorized. There's no question about that. In the Open Records Act, that middle column, there is no such provision. And we, for years, and some citizen activists in the southwest corner of the state, in the case that went up to the Court of Appeals, argued, well, if the legislature said in one statute you can charge for search and retrieval fees or research and retrieval fees, in another statute they didn't, you can't. Unfortunately, the Court of Appeals rejected that argument and looked at the legislative history that had said access to records without charge in an earlier draft of the original Open Records Act, and that was stricken. And there's legislative history that says that they intended to allow for a nominal fee under the Open Records Act. That's the word used, nominal fee. And in this case, called Black versus Southwestern Water Conservation District, that all the attorneys in the room know well, and was on the back of that blank sheet that you're listening to. The court authorized the charging of nominal research and retrieval fees under the Open Records Act for voluminous requests. And in that case, back in, I'm forgetting the year, 2003, something like pretty on the spot. I think they approved $15 and $20 an hour as nominal fees. But what the court made clear is that nominal means, as defined in that case, trifling in comparison to what would be expected. Trifling in comparison to the actual time spent. So $15 and $20 an hour in that particular case was approved because it was, as the court found, trifling in comparison to the amount of time that the Southwestern Water Conservation District actually incurred in compiling the records. So it's clear, and I've sat in rooms with government attorneys who've all agreed with the back of that blank sheet you're missing. The interpretation, it's not an interpretation, it's a literal quote from the case, is that it has to be trifling in comparison to the actual cost. So one thing you can do, long-winded answer, is to, cite the case and provide a copy of it to the attorney for the governmental entity you're dealing with, and say, are you telling me that what the time and expense it would cost to gather and produce these records is multiple times what you're charging me? Because that's what the case law supports. If you're charging me for search and retrieval, you can't charge me the per hour hourly rate of the governmental employees who are doing the work. That's not what the court has authorized. The other thing you can do in the real world is narrow your search. I mean, sometimes, you get a whopping bill, and okay, so I don't want every email Sheriff Stone exchanged with every entity. There were 50 some odd entities involved in Columbine's investigation. I'm really looking for this. I'm looking for the needle, not the haystack. So you can negotiate and work on limiting your cost out.
Although that is, depending on the story, it's not as easy. It's not easy to do that. Because sometimes you really do need to see the whole universe of records so that you can understand exactly what the story is about and how to tell it most properly. So that's sometimes a negotiation that fails because you got to get your arms around 10,000 or 100,000 records.
And the last thing, I won't get you to, there are efforts underway. There are people in this room who are involved in these efforts to change the statute and to make it clear that these types of fees that are being encountered increasingly, not only under the city's recently adopted fee schedule, but throughout the state. As Jim said, this industry, the news industry, is in dire financial circumstances. So is our state government and our local governments. I'm not telling you anything you don't already know. And that's why, in announcing the city's fee schedule, the city's press release said the city spent $200,000 last year responding to court requests. And, those of us who say that's not enough. They should be spending more. This is about transparency in government, and that's what we're paying them for, right? But there are governmental entities who also have a voice in the legislature and the ears of the legislators, and they are saying that we can't have a free access regime, and we have to increasingly pass costs on to citizens. And so that is going to play out. There was a legislator this term, Joe Salazar from Westminster, Thornton, who had introduced a bill to limit fees associated with cost and retrieval and copying, and he pulled that bill, but he's committed to introducing the bill next year and to work this year with a variety of groups to try to rein that in.